The infamous Menendez brothers, convicted of killing their parents in '89, are closer than they have been in decades to walking out of prison. This after Los Angeles DA George Gascón says he's now reviewing their case in light of potential new evidence. But here's what not enough people are talking about. Why exactly is he getting involved now? This evidence isn't even new. The real answer, 2 new shows just dropped about the case, and he's in the middle of a very tight re-election race. Now, there is no question the Menendez brothers killed their parents. What's being considered is whether they would have been able to avoid life sentences by introducing evidence that they were being molested by their father. They were allowed to testify about it in their first trials, where there were hung juries. Then in a second trial, the judge restricted some of the arguments about molestation, saying there wasn't any evidence to support it, and they were convicted. But now there is outside evidence to back it up.
Been given evidence. We have been given a photocopy of a letter that allegedly was sent by one of the brothers to another family member, talking about him being the victim of molestation. We've also got evidence that was provided by the defense, by his lawyers, that one of the members of the Menudo band alleged that he was molested by the father.
But this supposedly new evidence was detailed in a legal filing by the brothers in May of 2023. And the DA is acting as, just look at this. Oh, new evidence here. The real story is that the Menendez brothers' story is just blown up in the past couple of months. 2 Netflix shows that have come out in the past month have reignited interest in the case. And of course, George Gascón is the Los Angeles DA, and when in LA, celebrities talk. Apparently the DA listens. Kim Kardashian recently visited the brothers in prison, along with her sister Khloe and mom Kris Jenner. She then wrote an op-ed for NBC saying, "I've spent time with Lyle and Eric. They're not monsters. They're kind, intelligent, and honest men. My hope is that Eric and Lyle Menendez's life sentences are reconsidered." The LA election for district attorney set for November 5th, and if the polls are anything to go by, he's about to lose big. One poll has him trailing his challenger, former U.S. Assistant Attorney General Nathan Hochman, by 24 points. Look, I think this evidence and knowing the history of the case after 34 years, they should be released. But that doesn't explain the timing of the DA's interest in the case. Talk to Law and Crime Network, NewsNation legal contributor Jesse Weber. Jesse, you've been following this case closely. There's no other explanation, right, for Gascón showing interest in this now?
Sure looks political. I mean, this was filed a year ago. And look, prosecutors have discretion sometimes about when they respond. Out of all times to respond, though, given the interest of it, it's questionable. Look,
you think it's actually a weaker case than I do to release them?
The reason I think this is all politics is because the law hasn't changed. What do I mean by that? I mean, look, California law, you can recall a sentence and resentence somebody, first-degree murder, maybe a stretch. But here's the thing. They have been fighting for years in various courts, saying their convictions are illegal. They have been denied time and time again and have raised similar issues about sexual abuse and that this was self-defense and that the murder charge should be downgraded from manslaughter. Every time they have brought it up, they have lost, including similar evidence.
But this is the first time they have outside corroborating evidence to back it up. What other evidence they have?
At their second trial, and this is a misconception, there was evidence presented from witness, from people.
I'm sorry, I meant in addition to what was presented at the trial.
Correct. But but even if you take it as true, the Ninth Circuit, which was the last court to review this, said even assuming all the abuse evidence is true, it's not self-defense. This wasn't imminent.
It's not self-defense.
But that's what would have downgraded it from murder.
They could have gotten a manslaughter conviction without self-defense if it had just been the sort of thing where even if it was premeditated, they'd been abused by their dad. That's why the first juries hung, because those juries believed, at least some of them on that jury believed it.
That first trial was instructed about self-defense. The second one wasn't, and the high court said it wasn't a mistake for this second jury to not be instructed by self-defense because none of it, there was no evidence to support it. So the only reason, the second jury only had to decide, was it murder or not? That's it. Were they guilty or not?
And that's part of the problem.
Yeah, but again, I hear you, but I don't think it would have changed.
Jesse Weber, thank you. Thanks for watching. Go to joinnn.com to find NewsNation on your screen, and don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.